Hello, everyone, and welcome to Uncivil Law. I hope you're having a wonderful day. Today, we're here from a Court of Appeals decision from the Seventh Circuit coming out of Wisconsin. This is United States of America versus Joel Helding. In this case, Mr. Helding was convicted of possessing drugs. But how many drugs? What was the weight of the drugs, and how much should he be sentenced to? That is the issue at question. During sentencing, the amount got multiplied substantially. As a result, he was awarded another 7 years in prison from a lower reduction that he probably should have gotten. So the Court of Appeals is deciding whether or not this 7 additional years was proper, whether or not the district court properly multiplied the amount of drugs that he was convicted of. So let's get started with this. Police seized 143.7 kilograms of marijuana from Joel Helding's car and apartment, and he pleaded guilty to possessing over 100 kilograms. That's a lot of marijuana. That's definitely a lot of marijuana. I can't deny that. But at sentencing, the district court held him responsible for the equivalent of 4,679.7 kilograms, over 32 times the amount seized. This additional quantity was based solely on the pre-sentence investigator report account that confidential informants told law enforcement Helding was dealing significant quantities of methamphetamine during the relevant period. The drug quantity determination had a sizable effect on Helding's advisory guidelines, and it drove his ultimate sentence of 18 years imprisonment. A sentencing court acts within its discretion when it credits confidential informant statements about drug quantity, but when a defendant objects, the evidence supporting that quantity must be found to be reliable. While that step may prove modest, it needs to be taken lest a defendant face the risk of being sentenced on the basis of unreliable information. The statements here, without more, fell short of that threshold, so we reverse and remand for resentencing. So what's going on here is that a person is being convicted of a certain amount, and that by statute provides a certain range. So by law, the court can sentence you to anything in the range because it's what you've been convicted of beyond a reasonable doubt. That being said, in the federal system, there are sentencing guidelines that say, given your prior offense level, that is, how many crimes you've committed in the past, and given the seriousness of this offense, here is a range that you should sentence this person to, given those factors. So, where you fall on this continuum matters quite a lot in terms of the severity of the offense. And the court here said, well, we can up the severity of the offense because of this evidence we found based on this, so we can sentence you to more time. The Court of Appeals says you can't do that because you didn't show the confidential informants had sufficient reliability to show it beyond a reasonable doubt, or beyond preponderance even, because since you've already been convicted, it's anything within the range. So you only need to show preponderance of the evidence, but you didn't even show that. And so we're reversing so you can sentence accordingly. So that makes sense. In January 2018, a confidential informant told Wisconsin law enforcement that Joel Helding and his now wife, Valerie Flores, planned to drive a substantial amount of methamphetamine from California to Wisconsin. Law enforcement used the informant's tip to obtain a court order to track Flores' phone and thereby monitor the pair's location as they drove. Once Helding and Flores arrived in Wisconsin, state police stopped and apprehended him. The officers then seized 143.7 kilograms of marijuana from the car, while also finding him in possession of 2 firearms, a 9mm Smith & Wesson and a Ruger LCP .380, both of which are good choices of firearms. A subsequent search of his apartment undertaken pursuant to a warrant further uncovered 15.2 grams of marijuana and digital scales containing methamphetamine residue. I like the contrast of the fact that he is in his car. They found 143.7 kilograms, but at his house they found 15.2 grams. So he's much more a trafficker than a user, it appears. So yeah. A grand jury charged Helding with possessing and intending to distribute more than 100 kilograms of marijuana under violation of law and possessing a firearm in furtherance of the drug trafficking in violation of law. Helding pled guilty to both counts, which subjected him to mandatory minimum of 15 years imprisonment, 10 for the drug and 5 consecutive for firearm possession. Yes, under federal law, these firearm possession charges can really get you, and they can be quite serious, particularly if you have prior offenses. But yes, the way the federal law is written, basically in short, and this is obviously in short, but basically in short, if you use a firearm in furtherance of any crime, then that gets you additional time for the firearm violation. So you get, in this case, 5 additional years just for having the firearm. So if you didn't have the firearm, it would have been 10. But because you had the firearm, we tack on another 5, and by law, it has to be consecutive. So you get an additional 5 years for using the firearm. So that is the federal law. Yeah. And on a personal level, I don't actually have a problem with that. The problem with firearms is bad people doing bad things with firearms. So if you're a bad person, for example, moving massive amount of drugs interstate, which I think qualifies, and you're using the firearm in furtherance of that, then I see no problem sentencing you for the firearm because you're the problem and should be sent to jail. Fair enough. The U.S. Probation Office prepared a pre-sentence investigative report, often shortened as PSR, in advance of the sentencing. And this is normally what they do. Normally it is the probation office, and normally in many states too. Normally it is the probation office that prepares the pre-sentencing report and prepares like the recommended amount of time and things like that based on different things. So that's very typical. It's obviously used in the federal system, and it's used in a lot of states as well. In determining the drug quantity, the PSR recommended holding accountable for not only the 143.7 kilograms of marijuana the police found in his car and apartment, but also additional quantities based on application of relevant conduct rule in the sentencing guidelines. And the sentencing guidelines say that for guideline purposes, where a defendant jointly undertakes criminal activity, the relevant conduct includes all reasonably foreseeable acts and omissions within the scope and furtherance of the crime. Yeah. This application of this rule here meant the drug quantity determination needed to account for both the dealing of marijuana and the methamphetamine. According to the PSR, the confidential informants, or the CI, stated that they brought methamphetamine from Helding several times and relayed information on the quantities, prices, and frequencies of those transactions. The PSR reported that the confidential informant told law enforcement Helding possessed over a pound of methamphetamine on December the 16th, 2017, and had fronted the informant with a couple ounces every day or two for 2 months. The confidential informant sold the methamphetamine to others, returning a portion of the proceeds to Helding, and kept the balance as a profit. Now we're getting into minutia, but it's minutia I want to talk about, so we're talking about it now. We're now talking about this because I want to talk about it. It's my stream, so we'll talk about it. Yeah, that's interesting. So what is the difference, if any, between Adderall and Ritalin? That's a question I'd like to know the answer to, because presumably they're different drugs. They have different names, right? So I'm not the expert here. What is the difference between Ritalin and Adderall? Because I was under the impression that they were both speed. Are they different formulations of speed? Like, is it different chemical compounds? What exactly is the difference? I'd like to know, if anyone happens to know off the top of their head. That would be helpful information. The PSR included information from 3 other confidential sources. One of them, a different confidential source, was the informant who told law enforcement about Helding's trip from California to Wisconsin, under the mistaken belief that Helding and Flores were transporting methamphetamine instead of marijuana. The PSR quoted yet a different confidential informant as telling law enforcement that Helding once traded half an ounce of methamphetamine for a gun. And the report quoted yet a different informant as stating that Flores regularly sold the informant methamphetamine for $40 to $60 per eighth of an ounce. From this information, the probation officer estimated that Helding possessed and intended to distribute at least 64 ounces of methamphetamine during the relevant period. Where a defendant's conduct involves both marijuana and other drugs, the sentencing guidelines convert those drugs into marijuana equivalency for drug quantity purposes. So what that's basically saying here is that under federal law, all drugs are marijuana. All drugs are marijuana. So marijuana is the baseline drug, and all their drugs are converted into marijuana for sentencing purposes. So it's like, how much better or worse is it than marijuana? And we convert it into pounds or ounces of marijuana. So if you have 15 pounds of meth, you don't have 15 pounds of meth. You actually have whatever the equivalent of that is in pounds of marijuana. So that's just how they do this for sentencing guidelines. All drugs are marijuana. They use marijuana as a baseline. I don't know why. It's just what it is. Okay, let's carry on. I thought, per the FDA, Ritalin is methylphenidate. Adderall is dextromethorphan saccharate, amphetamine aspartate, dextrosulfate, and amphetamine sulfate. Well, yeah, amphetamine is amphetamines are speed, so amphetamine is speed. So metal methyl phendate hydrochloride doesn't sound like speed because it's not amphetamines. So that Adderall's amphetamine, but you get a specific enantiomer of speed. So if you have ADHD and scores some speed for medicinal purposes, the cops will still get you. Nor can you pass it off as Adderall because it'll show it's not. Yeah, fair enough. I buy that. Adderall is a straight up combination of amphetamine salts. That's what it sounds like. So it's not street amphetamine. So it's not street speed, but it's speed in different formulations, and you can tell the difference chemically, so you can tell the difference in a drug test. Yeah, fine. I get this. Where Ritalin is, yes, methylphenidate. They're both psychostimulants, but Ritalin is norepinephrine, dopamine, reuptake inhibitor, and I don't believe Adderall is. Yeah, that sounds better to me. Here's the actual drug sheet. Yeah. So it might be a psychostimulant, but it works completely differently because it works differently not by hyping you. It works differently by inhibiting reintake of a particular molecule. So you have as much hype juice in you, as it were. It's just more effective because the receptors are less uptake. So yeah, that makes a lot more sense. So your body is regulating it as opposed to being externally regulated. So that seems to make a big difference to me, at least. Like, I don't know much about chemistry, but it would seem to make a big difference. So, I wouldn't qualify Ritalin and Adderall as the same in that sense. There's a big difference, at least in this man's humble opinion, with dumping you with a stimulant versus dumping you with something that prevents reintake of the stimulant you're already naturally producing. So, yeah. Not to mention that the stimulant in the Ritalin case is natural because you're already producing it, right? So it's not artificial. So your body's more able to tolerate, I would imagine. My confusion was a psychologist told me if someone without ADHD took Ritalin, they'd be bouncing off the walls. But if you have ADHD, it speeds up the monitoring part of your brain, which becomes normal. But that was in the 90s. Okay. Yeah. So I think we are now sufficiently clarified. So yeah, I think what Ritalin is what I'm on, and it definitely worked much better for me than Adderall. Because I said Adderall for me was just taking like large amounts of caffeine. It made me like just hyper. It didn't do anything for me. It didn't work. So, in preparing the PSR here, the probation officer converted the meth and added it to the 143 kilograms of marijuana, and therefore it converted it into 4,679 kilograms of marijuana. So you see how that conversion factor works, right? You get a multiplier, and suddenly you have 4,500 kilograms more marijuana than you did in the first place. So that's how that works. Helding's advisory sentencing range likewise jumped through the roof. If he had been responsible for just the 143 kilograms of marijuana seized, his offense level would have been offense level 26, and the sentencing range would have been 120 to 150 months for the drugs. Add to the 5-year minimum he faced for a gun offense, and the total range would have been 180 to 210 months. But when the drug quantity skyrocketed to 4,679 kilograms of marijuana, Helding's offense level increased to 32, and the sentencing range increased to 210 to 262 months, adding the 5 years for the firearm, and the total became 270 to 322. Put most simply, the spike in drug quantity increased the advisory range by over 7 years. Helding objected to the inclusion of the methamphetamine, arguing that nothing corroborated what the CIs, the confidential informants, reportedly told the law enforcement. Nor did he add, did the report include any explanation of why law enforcement found the CI's information to be credible. Helding's objection was clear. The case involved no controlled buys with any CI, and the search of his apartment revealed only residual amounts of methamphetamine consistent with personal use. So here he's getting to the heart of the question. The police didn't discover any meth worth talking about, and they haven't said why these CIs are credible. They're not saying that there was a controlled buy or anything else. They're not saying why they were believable. So he's saying that it's not sufficient for the court to rely on. So let's get further. The probation officer rejected Helding's objection to the addendum to the report. The addendum explained the probation officer did not have the means or responsibility to investigate witness credibility. You kind of do a little bit, it has to be reliable. So you have a little bit of duty there, yeah. It stated only that CI1 and CI2 statements factored directly into the drug quantity calculation because those statements were detailed enough to include dates and quantities of Helding's alleged methamphetamine sales. On the basis of this information, the report calculated Helding's advisory range based upon a drug quantity of 4,679 kilograms of marijuana, an amount the probation officer saw as conservative in light of the accounts of confidential informant 1 and 2 supplied to law enforcement. Sentencing began with the district court determining Helding's advisory guideline range. Helding again objected to the inclusion of the methamphetamine in the drug quantity determination, disputing the accuracy of the confidential information supplied about the methamphetamine sales. The district court overruled the objection, finding the government had shown Helding's possession of methamphetamine by preponderance of the evidence. The court reasoned it this way. Indeed, as to the quantities, both confidential informants were able to provide specific information related to defendants' involvement in the sale of drugs, including dates and quantities. Absent contrary evidence, therefore, I overrule the objection. The district court next turned to Helding's criminal history and found that his 2 prior felony drug convictions made him a career offender. Helding's career offender status meant his guideline offense level automatically became 37, regardless of any drug quantity determinations. The court found that Helding's career sentencing range was from 322 to 387 months. The district court took one final step. Recall that Helding faced a total mandatory minimum sentence of 180 months for his marijuana and firearm convictions. The court compared Helding's non-career offender range to the statutory 180-month minimum and decided that the sentence somewhere in between was appropriate. The court therefore sentenced Helding to 216 months, about halfway between the 180-month mandatory minimum and the lower end of the 248-month non-career offender range. Helding appeals. He emphasized the importance of the drug quantity determination to his sentence and urges us to hold the district court need to do something to find the confidential information dependable before relying on it. So now, with that predicate out of the way, the appeals court is going to get into the issue of whether or not the district court or the probation or parole office did enough to consider whether or not the confidential informants were reliable. Was enough considered? Was enough presented or not? So now they're going to get into the analysis based on the facts, whether or not this is sufficient. So let's get started. It's good analysis of what you need to have a confidential informant to be reliable. So let's see what it takes to be a reliable confidential informant. Says logically that this mandatory minimum is greater than the cop committing second-degree murder. Yeah. Our reading of the sentencing transcripts leaves us with the impression the district court overruled Helding's objection because the information supplied by the confidential informant was detailed. While the observation appears accurate, the reasoning came very close to the district court saying it credited the confidential informant because of the inclusion in the report. What concerns us is that the reasoning prevailed over Helding's objection, with no step being taken to find some modicum of reliability of the information supplied to the probation officer charged with preparing the report. More to it, nowhere did the report contain any information, even a representation by law enforcement, that the information statements were known to be reliable. Confidential informant 1 and 2 specified date and quantities of the alleged drug sales, but specificity alone, in the face of an objection, does not make information reliable. Perhaps recognizing this shortcoming in sentencing on the record, the government urges us to conclude any error in the court's finding was harmless given his status as a career offender. We decline this invitation. After finding that Helding qualified as a career offender, the district court then pivoted, invoking the discretion we recognized in Corner, and ultimately imposed a sentence driven almost exclusively by the guideline range resulting from the drug's quantity finding. In these circumstances, where the exercise of Corner discretion sidelined with the career offender guidelines, we cannot agree that any error with drug quantity finding was harmless. It is impossible to read the sentencing transcript and not recognize the massive influence the drug quantity had on Helding's sentence. So I think the Court of Appeals is quite rightly ruling that this is not just a trivial thing. It's not harmless error. He might be a career offender, and that affects his status on one level because career offender status is one level of the chart, the matrix. But another level of the chart matrix is the seriousness of this offense. And so the seriousness of this offense might be influenced, but you can't just take it as given and factor it in. You have to find it to be reliable. So it's not nothing. It was worth up to 7 more years of sentence. So it's like you got to find some support for why this is credible beyond the specificity. Why are the police finding this credible? Reliability is a central ingredient of due process analysis. When the district court sentences a defendant based on drug quantity guidelines, it must find the government's information sufficiently reliable to determine drug quantity by preponderance of the evidence. We have emphasized that where a district court relies on evidence that substantially increases drug quantity, it must take care on determining the accuracy of that evidence. We have underscored these due process safeguards in addressing previous challenges to reliability of information included in the report. But the sentencing record here did not contain enough to find the confidential informant provided information sufficiently reliable to influence Helding's guidelines, determination, and ultimate sentence. The district court exercised the discretion we recognize in Corner and deviated from the career offender range, only then to find Helding responsible for over 32 times the amount of marijuana seized, a massive spike in drug quantity based only on statements made by confidential informants to law enforcement and memorialized in a report. In these circumstances, that fell short of protecting a defendant's right to due process to be sentenced on the basis of accurate information. So this is the United States Court of Appeals for the Seventh Circuit decision of United States of America versus Joel Helding. In this case, we learned that Mr. Helding was a drug trafficker, and a confidential informant informed the police that he was trafficking drugs. They pulled him over and found lots of drugs, but not the drugs the confidential informant said he was carrying. Nevertheless, as part of the sentencing, the trial court sentenced him to time for the methamphetamine he never was found with because they found the confidential informants were specific. But here the Court of Appeals rules specificity alone is not enough. You need some reason to say that these are reliable. And particularly in light of the fact you didn't discover any meth, the reliability is at least questionable. So you need to provide some background to say that we can in fact rely on this, and it wasn't there. So the Court of Appeals sentences it back for resentencing in light of this, and that's the end of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.